And also, this paragraph is a very, very important paragraph, mentioned paragraph 52, where he mentioned two important judgments, very, very important judgments, Menaka Gandhi versus Union of India case, and also Puttaswamy case. Explaining these two judgments. See this small paragraph. You can see the heart and soul of Menaka Gandhi and Puttaswamy judgment in this paragraph, because the Dhulia said school is a public place. Yet drawing a parallel between a school, a jail, and military camp is not correct. Again, if the point which was being made by the High Court was regarded discipline in a school, then that must be accepted. It is necessary to have discipline in school, but discipline not at the cost of freedom, not at the cost of dignity. Asking a pre-university school girl, to take off her hijab at her school gate is an invasion of her privacy and dignity. It is clearly violative of the fundamental rights given to her under Article 19, Clause 1A and Article 21 of the Constitution. In my point of view, it is not a question of Article 25. It is a question of Article 19, 1A and Article 21, not delivered by this court, which is delivered by the Menaka Gandhi versus Union of India and Puttaswamy case. So, why I am saying that Dhulia is right and Gupta is not? Because Dhulia appreciated the previous judgment. Dhulia appreciated the previous judgment in a way to protect the constitutional values and rights. But at the same time, Gupta is also interpreted all these cases, but did not appreciate the Constitution in such a way that the Constitution is a book of compassion and a book of tolerance, like Chinnappa Reddy and Justice Bhagavati or Justice Krishnaiyer did. So this is a very classical paragraph, while actually Dhulia find out the heart and soul of this issue, because this is a question of Article 19, Clause 1A and Article 21 of the Constitution. This right is this right to her dignity and her privacy. He carries in her person, even inside her school gate, or he's in her classroom. It is still her fundamental right, because you cannot separate a birthright, whether you are in, doesn't matter whether you are in home, whether you are in a school, or whether you are in an office, because it is your birthright, not a derivative right, as mentioned, described by the High Court. So I think it is also very important. And one of the thing that why I am saying that Dhulia's judgment is more relevant, because he appreciated the international human rights standard, which is delivered by the three important judgment of the United States Supreme Court and one important judgment of the South African Supreme Court, and also Constitutional Court, and also one of the judgment of the Privy Council, where in paragraph 57 he mentioned a story, and the story that I think you can see that story. I just read that story. That is a Sunil. In this particular story, Suneli was a student of class 10 of Durban Girls High School, and the code of conduct of the school prohibit wearing jewelry in schools. When Suneli was in class 10, her mother gave her a nose set, which was not a fashion statement, but a part of Suneli's Hindu Tamil culture. The school objected to the nosted, and Suneli was asked to remove it, like hijab. When Suneli refused to remove, the no-state, her mother was called. When Sonali refused to remove the no-state, and her mother was called, and her mother reasoned with the authorities that this is a part of her Hindu Tamil culture, and it cannot be removed. Ultimately, Sonali, through her mother, had to file a petition before the Equality Court, where such matter of discrimination are heard. Since Sonali had alleged discrimination by her school, the equity, what was the decision of Equity Court? The Equity Court held that though a prima facie case for discrimination had been made, out, it could not be termed as unfair. Thus, dismiss her case, like Karnataka High Court did. Like Bijoy Emmanuel's case, what was happened? Because that case was the similar case. So, because Kerala High Court was dismissed the petition of in that particular case, and Supreme Court rejected Kerala High Court decision, because this is all cases are similar in nature. Thereafter, the matter was taken in appeal before the High Court, which allowed her appeal and held that asking Sonali to remove her no-state amount to discrimination, which is wrong. Both the school and the administration went to the Constitutional Court, which heard the matter and again decided in favor of Sonali. So this is a story. This is a beautiful story mentioned by Julia, quoting the international standard of similar liberal democracies like United States of America and South Africa and England. This was the incident and case reported in South Africa. So I will conclude it within 5 minutes. I think in the paragraph 78, he mentioned the preamble to the Constitution secured to all its citizens liberty of thought, expression, belief, faith, and worship. It is a preamble against which seeks to promote among them all fraternity. That is a very important word, assuring the dignity of individual and the unity and integrity of the nation. The government order dated 5th February 2022, and the restriction of wearing hijab also goes against our constitutional values of fraternity and human dignity. So what Julia did, he saw the heart and soul of Indian Constitution, especially the heart and soul of Indian Constitution that he used. He used Article 32, because Article 32 is a fundamental right, and it is also the jurisdiction of the Honorable Supreme Court. And Ambedkar said it is the heart and soul of the Indian Constitution, because all fundamental rights are meaningless unless it is effectively enforced. So Julia used Article 32 for enforcing the fundamental right of the citizens, because it was his aim when he using Article 32 of the Constitution. And also he mentioned the importance of preamble, because Nehru said the preamble of the Constitution is the heart and soul of Indian Constitution. And also he interpreted Article 19+1A of Indian Constitution in that sense, because Article 19+1A of Indian Constitution is actually the heart of the democracy. So it will the girls students' right will come under the purview of freedom of expression, which can be reasonably restricted by the state on specific grounds. That grounds mentioned in Article 19+2, but in the government order, the ground mentioned in the government order is equity, equality, and public order. But the public order mentioned in the order has no connection with the public order that is mentioned under Article 19+2 of Indian Constitution. So this restriction is an unreasonable restriction, because they have no right to impose that restriction, because there is no specific grounds. So that is one of the reason why this paragraph 78 is a very important paragraph, because Julia explained the importance of the preamble, which is the heart and soul of Indian Constitution, as according to the first Prime Minister of India, and he is also a member of the Constituent Assembly. And the preamble to the Constitution secured to all its citizens liberty of thoughts, expression, belief, and faith and worship. It is the preamble assurance and promise. Again, so the preamble against which seeks to promote among them all fraternity, assuring the dignity of individual and unity and integrity of the nation. So the government order dated 5th January 2022, and the restriction on the wearing of hijab also goes against our constitutional values of fraternity and human dignity. And in the same paragraph 78, he also mentioned that Dr. Ambedkar's quoting, because Dr. Ambedkar said, according to his words, mentioned in the Constituent Assembly, that my social philosophy may be said to be enshrined in these words, and that is liberty, equality, fraternity. Let no one, however, say that I have borrowed my philosophy from the French Revolution, because we are saying that these concepts of liberty, equality, and fraternity are derived in the Constitution from the French Revolution. But what Ambedkar said, it is in my concept, it is not derived from the French Revolution, because I haven't. My philosophy has roots in the religion and not in political science. I have derived, I have derived them from my master. My master means the Buddha. So Dr. Ambedkar gave the highest place of fraternity, as it was the only real safeguard against the denial of liberty and equality. This principle of liberty, equality, and fraternity are not to be treated as separate items of Trinity. They form the union of Trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. So this is actually the very important thing. And lastly, he mentioned in paragraph 79, I think it is also a very important point, because he interpreted the Constitution as a document of compassion, a document of inclusiveness, document of freedom, document of possibilities, by stating the word of Justice Chinnappa Reddy in a landmark historical judgment having similar identity in fact and law of the present judgment. Ditto Emmanuel Rice's State of Kerala. Our tradition teaches tolerance, our philosophy preaches tolerance, and our constitution practice tolerance. Let us not dilute it. So I think Dulia's judgment is a fair judgment, and that judgment will be upheld by the higher bench. That is my conclusion. Thank you very much.
Thank you, sir. Thank you for your valuable insights. Well, moving on, Dr. Lowell Mansar is unable to join us today due to prior engagements. So next we're going to move on with the Q&A section. So how this works is you can jot down your questions in the chat box, and the same will be brought into Safi Mohan sir's purview. So go ahead and put down your questions in the chat box. Thank you. Sir, okay, so the first question is from Vishnu Sukumaran K. And the question is, can you explain essential element of religion, doctrine, which is established by Honorable Supreme Court of India in accordance with this specific case? And does that doctrine get accomplished here in this case?
So actually, the established religious practice is not a question in this particular case, in my point of view. In my point of view, the question is Article 19 clause 1A, and Article 21 of Indian Constitution. I already mentioned the judgment delivered by the Menaka Gandhi case and Puttaswamy case, because I already mentioned the fact that we have to interpret the Constitution in such a way that we have to accept uh, uh, the compassionate face of the Constitution. That is the best way. So I would like to say two important things, because the Ambedkar also in his Constituent Assembly said, that is mentioned in Julia's judgment, that Ambedkar also said we have to only look into the essential religious practices. But at the same time, it is very difficult to explain what is the essential religious practices because of the diversity of the religion and culture of our country, because our country is the most diversified country in the world. That is one of the reason why this paragraph that is taken from Shirurmat decision is, I think, which is very relevant, where Justice Mukherjee said a religion undoubtedly has its basis in the system of beliefs and doctrines, which are regarded by those who profess that religion as a conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine of belief, because Justice Gupta said it is a doctrine of belief, but Justice Julia saying, by quoting the judgment, the statement of Mukherjee, that it is beyond belief. The religion is not only a doctrine of belief, but a religion may not only be laid down a code of ethical rules for its followers to accept. It might prescribe rituals, observance, ceremonies, and models of worship which are regarded as an integral part of religion, and these forms and observance might extend to the matter of food and dress. So I think in that respect, it is very clear, which is mentioned by Justice Julia. Even though this case was mentioned, the fact that the religion considered wearing of hijab is not mandatory and not prohibitory. It is not a haram, but it is also not prohibitory. It is not a mandatory. So, but it is a practice. But at the same time, this practice, according to this religion, is a practice which is practiced by this religious community time immemorial. So I think in that particular point, the court interpreted this particular point in the light of Quran, but at the same time, they never find the fact that it is an essential religious practice. But in my point of view, that is not a relevant question. It is whether it is a essential religious practice or not is a not a important question. But the question is whether there is any violation of Article 19(1)(a) of Indian Constitution. For example, I have a daughter. She is studying in 4th standard. Tomorrow, she is saying the fact that she want to go to school with a handcraft, headcraft, or a hijab. So she's saying that I want to do that, but how can a state regulate it by using Article 19(2) of the Constitution? Because I think it is not possible, because she didn't she is not committed any of the the state cannot impose any restriction as mentioned in Article 19(2). So that is in my point, because I already mentioned the fact that our constitution is very liberal and our religious concept is very liberal, and we are as a nation from our since our independence, we are moving from, according to judgments, we are moving from not restriction to restriction, but freedom to liberty. Yes.
Okay, sir. The next question is from Vishnu himself. And the question is, sir, you had mentioned religious practice. Is hijab among the holy essential pillars?
No. According to religious belief, it is clearly mentioned in the judgment. You just gone through the judgment where it is clearly mentioned the fact that it is actually not an essential religious practice in its strict sense, but at the same time, it is a practice which is accepted in Islam as a freedom of choice. That is the word that I use, or it is a practice which is accepted by the religion as a freedom of choice. It is the right word, freedom of choice. So freedom of choice means it is neither prohibited, not restricted. It is not mandatory, neither mandatory, not prohibitory. That is called the freedom of choice. So that freedom of choice is actually the heart of the Indian Constitution, I would say, because that freedom of choice give you, that is mentioned in the Bijoy Emanuel case, because you have a freedom of choice to speech, and at the same time you have a freedom of choice of silence. So that is an indication of liberty. That is, we are moving from freedom to liberty. So that is also essentially one of the most important point which is mentioned in the preamble of the Constitution also, which was so interpreted by judiciary in Puttaswamy case and Maneka Gandhi case, and also in the Bijoy Emanuel case.
Okay, sir. The next question is, could you read TMA Pal Foundation versus State of Karnataka 2002 8 SCC 481, that's the citation, along with this case?
Actually, TMA Pi, I think TMA Pi case, is it right?
Yes, sir.
Yeah, TMA Pi case was mentioned, and it was actually mentioned in the judgment of Gupta as well as in Dhulia, but I think it has no so relevancy in this particular case. When you read this judgment, you will understand that this is just mentioned in the judgment, but it has no relevancy, more relevancy in the judgment. The relevant judgments are both are mentioned in the judgment. I think both judges are appreciated that judgment. That is, I think, Maneka Gandhi, Bijoy Emanuel, St. Stephen's College, Indira Sahini, then Koilo case and National Legal Service Authorities case, and also Puttaswamy case and Subramanya Swamy case, and also Navjot Singh Johar case, and also Prithviraj Chauhan case. These are some of the important cases which has close direct relationship with this issue in terms of the different right of the girl students are concerned. I already explained what are the different rights, which will includes right to development and right to self-determination, and also a cultural rights, or even a right against discrimination, which is untouched in this particular case. So it is mentioned by Gupta in his issues, but at the same time, it is not so mentioned by Dhulia in his judgment. But at the same time, he framed all these issues in the light of so many judgments, and he appreciated the previous judgment. That is what the Dhulia did. But at the same time, what Gupta did, Gupta also mentioned all these judgments. Gupta is not wrong, because Gupta interpreted a constitution in such a way that a constitution is a book of control. That is the book of discipline, book of restrictions and regulations. That is the only thing that I found. The different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is, I think, is a constitutional